Hello everybody, I am back for section 2 of the homework review, looking now at the questions on page 159 and 160, numbers 3, 7, and 10. This is the homework at the end of chapter 6 on tort law and cybercrimes. So starting with number 3. Number 3 asks you to look at a situation, a real situation, and come up with what sort of torts you think might apply. So we have inmates here who are becoming injured because of beatings, at least this is what they claim, from beatings conducted by corrections officers. So what would be the torts that could form a basis for this lawsuit? And there are any number of things that you could propose. I would say probably the most common one, the one that most of you gave, and correctly so, is battery. Battery is unwanted touching, basically. And battery, it can be hard to prove in the prison environment that it was not a justified use of force. However, if it was unjustified, then it would be considered battery, because the guards, without reason and without consent, touched the prisoners in a way that caused them severe physical injury. Assault would be another one. Some of you mentioned assault. Assault generally is the intentional tort where you make somebody fear that you're going to commit battery, basically. So, for instance, assault would be waving your fist around and saying, "I'm going to hit you," when you clearly have the means to do so, and to the other person it may look like you have the true intent to do so. So you've put them in fear. Battery would then be actually hitting them in the face. Those I think are the two most straightforward approaches here. There are, outside of tort law, there's some interesting constitutional issues that could be brought up at a trial, cruel and unusual punishment, things like that. But I'm guessing, well, I know most of you put battery and some put assault, and those really are the most straightforward intentional torts. As far as unintentional torts, some of you mentioned negligence, and I could see that it would be worth arguing a case for negligence here. It might be a little difficult, because beatings in general are considered intentional. At the same time, you could maybe have a negligence case against the prison administration for not adequately, they have a duty to keep the prisoners safe. They breached that duty by allowing these problems to continue. These problems, the beatings, were the cause of injury, and actual injury occurred. So you could have a case based on negligence as well, though more likely against the prison administration or the state government that runs the prison than you would against the guards. Any tort case against the guards is probably going to be an intentional tort. So moving on to number 7. Number 7 is a major Supreme Court case. It is the New York Times versus Sullivan. So this case was in response to a newspaper advertisement, full-page ad, that was referencing Martin Luther King Jr.'s arrest. And it claimed that that his arrest, I'm going to pull up the details here, that the arrest was designed to inhibit the furtherance of civil rights, and that the arrest was part of a campaign to destroy Martin Luther King Jr.'s efforts to integrate public facilities and encourage African Americans to vote. So the Sullivan, who was the city commissioner of Montgomery, Alabama at the time, filed a lawsuit for libel, and libel is being defamed personally. Somebody saying something about you that isn't true to harm you in some way. This went all the way to the Supreme Court. And the Supreme Court decided that the First Amendment, free speech, protects the publication of all statements, even false ones, if it's about the conduct of a public official, unless actual malice is involved. And actual malice they defined as with knowledge that it's false, or in complete reckless disregard of whether it's true or false. Now, in this case, the statement wasn't really verifiably true or false. You couldn't really prove either because it was the opinion of the people who took out the ad. So while it may have been damaging to Sullivan's reputation, Sullivan was not able to show to the court that these people were specifically out to get him, that they had malice in their hearts and were deliberately saying something that they knew or should have known was false. So Sullivan's case collapsed, and the New York Times won their case. This is considered a major victory for free speech, one that's still talked about quite a bit, even though it did happen quite some time ago. The next one is number 10, and for number 10 I want to fill in some details for you, because there are some important details here that your textbook doesn't mention that I think make this case easier to understand. So first of all, Michelle Whiteman here, so she crossed a train track with the gates down and the lights flashing, and she got hit by an oncoming train. She didn't see the oncoming train because there was a broken down train parked, getting repaired, and that was obscuring the view of the rest of the track, so you couldn't see it. The details that your book leaves out, first of all, this was a 16-year-old. She'd just gotten a driver's license. And also, she was not the only car that did this. She was just the only car that got hit. So she came up to the crossing, and saw the stopped train being worked on, which its presence there was activating the alarm system and the barriers, and saw all the other cars just going, around this gate and continuing on. So she did the same, followed the rest of the cars around the gate. Unfortunately, when she did it, a train was coming, and she was hit and killed. So, like I said, there are a few more interesting details there, and this was another major case that looked at does the fact that she had some degree of involvement in this. She, crossed a crossing that had indications that it should not be crossed. And this went up to the Supreme Court, just like the previous one. And there was the award at the initial trial was $15 million. This happened in 1989. So $15 million is a lot of money now. It was a massive amount of money in 1989. The question is, should her involvement, her negligence, be taken into account? A jury decided that the train company, for parking a train that blocked the view of the track and not putting somebody out to warn traffic when other trains were coming, made them 60% responsible for the accident. And the jury awarded Michelle's mother $1 million for wrongful death of her daughter and $2,400 for the loss of the vehicle. So generally, Ohio law does not allow punitive damages, damages that are intended to sort of punish a company. After a round of appeals, a new jury awarded $25 million as a settlement, because you can't have punitive damages for wrongful death, but you can have them for property damage. And since they were found 60% responsible for the $2,400 loss of the car, a jury could award punitive damages based on the loss of the car. A little convoluted, but it works. A judge later reduced that amount to $15 million. They thought $25 million was excessive. Went up to the Ohio Supreme Court. It was upheld because the railroad employees didn't do anything to warn of the oncoming train, and the injury was catastrophic. And then that was upheld further on. Now, the fact that Michelle was found to be 40% liable for the accident that killed her means that the amount of those damages would be reduced by 40%. In other words, by the amount of her contribution to the accident. And she would be awarded then, or her mother would be awarded 60% of that. So it sort of, factors in the respective negligence of each party, because in this case the accident happened because both were negligent. Michelle probably would not have crossed the barriers had she been able to see the other train coming. Referring specifically to the question that's asked in the textbook, should her negligence be a complete bar to recovering damage? And the answer is no. It used to be the case in a lot of states where it was. It's very rare now that that happens, and it is in most states decided by a percentage. Please let me know, of course, if you still have any questions about these cases. I'm happy to fill out anything, or if I can, in places where I can find the case, I can send you the case if you can't find it on Google. And I will talk to you next week.